Hi folks, and welcome back to Contract Law. This is video 3 in the video series on discharge of contracts. And in the first video we laid the foundations. In the second video we really explored discharge by performance and when and how the defaulting party with substandard performance might be able to claim some payment back. Now we need to look at discharge by agreement. Now, the first way you might find a contract discharged by agreement is where one of the conditions that the parties have set out in the contract fails. Often a contract will set out a term that is usually an event, and often that event is to be brought about by one of the parties. And the parties specify in the contract that if that event doesn't occur, then the contract will be discharged. There has been a bit of debate around classification of these kinds of terms, and the old classification was conditions precedent and conditions subsequent, conditions precedent to performance. Really it just boils down to this. Sometimes you will have a contract term of this nature that actually prevents a contract from arising at all between the parties if the event doesn't occur. The classic case of this was the McCall Australia case, where there was a lease, there was a potential to actually renew the lease. One of the conditions for renewal was that the rent had to be paid on time in the initial period of the lease. You guessed it, the tenant actually didn't pay the rent on time in the first period of the lease. They wanted to renew and they lost their right to renew. Why is that? Because payment on time was a condition precedent for renewal. Generally speaking, courts will struggle to find their way around that kind of conclusion because it's fairly drastic to actually conclude that the parties that actually were never in a contractual relationship at all. It means that there are no rights that have ever existed between the parties, and that can make finding remedies in that kind of circumstance sometimes difficult. So courts usually will specify that this kind of term, where the parties need an event to occur before either of the parties will perform their obligations, will be a condition subsequent or condition precedent to performance. That is, you don't have to perform unless this event occurs. If the court concludes that the term is of this nature, then the contract has arisen between the parties. So there are remedies and all sorts of things available on the title. It's effective to make title pass and so forth. But the contract's terminable on the failure of the condition subsequent. And here we have all of those kinds of lovely conditions that you usually find in things like land sale contracts or properties, real estate contracts. So Perry and Coolangatta Investments, just one example there of a purchaser contracting to buy a property subject to the condition that they first sell their own pre-existing property so that they had the cash to buy the new property. Very, very common. You guessed it, the purchaser found it very difficult to sell their pre-existing property to get the cash to buy the new property. Months go by, the vendor gets sick of it and says, I want to terminate. There's a dispute between parties, they run off to court, and the court says the contract subject to sale of the purchaser's own sale of their own home was a condition precedent to performance. That is, the vendor didn't have to perform and settle on the sale of that house to the purchaser unless and until the purchaser had actually on-sold their property. They hadn't done so in a reasonable time, so it was quite within the vendor's rights to terminate. So these are conditions subsequent or conditions precedent to performance. That's normally what a court will conclude this kind of thing is. But there are a stack of other ways that you can discharge a contract by agreement, or you can change it up if you're not really happy with it. Firstly, if you don't want the contract to run in the way that you've agreed, you can certainly agree to vary the contract. The original contract stays on foot. You just simply change some of the terms as to how you want them to operate in the future. But in terms of actually getting out of the contract by agreement, the two big ticket ways are novation and discharge. And we'll talk a little bit about variation, novation and discharge in this video, and we will also talk about some non-contractual ways that the parties can either get out of their obligations completely or partially, and they are waiver and abandonment. But for contractual means of rearranging the deal, variation, novation, discharge, you're going to require all of the usual antecedents of forming a contract, including consideration. Now, the issue of consideration does sometimes cause problems. However, I guess the big thing to take away from thinking about consideration for restructuring a deal is that it can usually be done very simply just by way of structuring the deal as a deed. If you do it as a deed of release, for example, then you're not going to need consideration, are you? Because it's not a simple contract that requires consideration. It is a solemn contract, and as a solemn contract, a deed, then all consideration is irrelevant. So if you don't structure your rearrangement as a deed and you do need to find consideration, you need to bear in mind a couple of points. If both parties have yet to perform their obligations under the contract, the position is relatively clear. Both parties agree to accept each other's agreement to bring their contractual obligations to an end, so you have a mutual release, mutually providing consideration one party to the other. No problem there. The area where problems arise really is where one of the parties has actually performed some or all of their contractual obligations. They are going to need fresh consideration from the other party before agreeing to release them from their obligations. And this is where you have what we call accord and satisfaction. Accord is the party's agreement to release the party that has yet to perform, and satisfaction is the consideration that the party who hasn't performed gives to the party that has performed. Accord and satisfaction. If you have that kind of arrangement, then contractually you're going to be bound to the rearranged deal and there will be no consideration problems. But as I said, the easiest way to structure these kinds of things is via a deed. Simple, clean, and neat. Now, the first way that you can rearrange a deal is variation, as I said before. It is a fresh contract. So you need to think of the old contract being tinkered around with, but the agreement on the new terms itself is a fresh contract. So that's why you're going to need all of the antecedents for contract formation in relation to the newly agreed terms. The issue for variations that sometimes comes up is where the statute of frauds legislation requires an agreement to be in writing. If that's the case, and I'm thinking here of the Property Law Act, for example, in Queensland, that requires all land contracts to be in writing. If that's the case, then any variation is also going to have to be in writing. You can't orally vary a contract that's required by the statute of frauds legislation to be in writing. You can discharge a contract required to be in writing by that legislation orally, but you cannot vary it orally. Okay, that's the issue of variation. A variation to bring in another party and flick out one of the original parties is called a novation. Now, with a novation, similar to a variation, you wind up with a fresh contract, so you're going to need all of those antecedents to contract formation again. And the fresh contract will be between one of the original parties, the first party, and the third party newcomer to the deal. Generally speaking, the contract that ends up on foot between those parties is exactly the same as the first original contract between the first and second original party. Sometimes extra things are put in, sometimes some terms are taken out. Usually you'll have a duplicate arrangement between the first and third party. The second party then exits the original deal, and that original contract is discharged. So, the most important thing to remember about a novation is that it cancels the entire contract, discharges the entire contract between the first and second original parties, and it brings in a new contract, as I said, usually on the same terms, between one of the original parties, the first party, and a newcomer, third party. The consideration, what's the consideration involved here if you're going to structure it as a contract rather than a deed of novation? Well, A is giving up rights to make B perform, so B is going to have to give some consideration to A for that. So B will either pay some money to A, or B will procure the newcomer third party C to perform for A. All parties have to consent to the arrangement, and the main case here is ALH Group Property Holdings and Commissioner of State Revenue. So the first of the non-contractual ways to rearrange a deal is waiver. And a waiver, well, there's a lot of uncertainty and unclarity around the way that waiver operates as distinct from, for example, variation and the regulated estoppel. All do very similar things. Variation of a contract obviously is a contractual way of rearranging a deal. Waiver and estoppel are things that happen outside the contract, representations that are made outside the contract that affect the way that parties can enforce their contractual rights. So a waiver is where one party indicates that they're not going to rely on their strict contractual rights. So already you can see parallels with representations made for which were found in estoppel. However, for a waiver, there is no actual tinkering around with the terms of the contract. There's no actual changing of contractual rights. Consequently, there's no need for writing, and there's no requirement for consideration. You're not actually changing the deal officially, you're just doing something extra contractually that affects the way that you can enforce your rights. How can you tell waiver apart from variation? Well, the courts have been struggling with this one for quite a while. Usually, a waiver will only alter one party's rights. Usually, it only benefits one party, doesn't substantially change the contract, and the alteration is freely, perhaps sometimes reluctantly, given. Often they'll say that a waiver generally relates to the mode or method of performance rather than the contractual right requiring performance. So, for example, often in land sale contracts, if one party requests an extension of time, they'll often classify that kind of thing as a waiver rather than a variation of contractual rights. So that's the issue of waiver. As you can see, there's parallels, aren't there, with estoppel, and sometimes it can be very difficult for a court to try and prosecute through and find the right label for what's actually going on in the circumstances. A lot of courts have actually gotten fed up with the labels and said that it doesn't really matter what label you use. The important thing is the substance of what's going on. And waiver, as I said, is just another one of those ways that you might rearrange your deal. Hartley and Hyman's, Levi and Cohen, Goldberg and Trotton are the cases that you need to look at for waiver. Abandonment is the last way that you can potentially find yourself out of a contractual deal. Again, this is a non-contractual method of discharge, and it occurs where both parties indicate that basically they've given up, the contract shouldn't be performed, or the court says, hang on a minute, too much time has elapsed now, we're just going to conclude that the parties have abandoned things here. You need to look at the objective intention of the parties, and that's where it really becomes important. In Fitzgerald and Masters, we had a contract for the sale and purchase of a half interest in a farm. Payments were made for quite some time, I believe more than half the payments were made. And then there were non-payment of instalments for 17 years. Now, that's an extraordinarily long time, isn't it? But that was by mutual agreement there. Then Fitzgerald died, but just before he had died, a couple of years before he died, they had resumed correspondence about this deal, and then, unfortunately, after Mr. Fitzgerald died, his executors refused to honour the arrangement, so not surprisingly, Masters decided to enforce the agreement. In that particular case, it was held that the contract had not been abandoned despite the very, very, very long lapse in payment of instalments. One of the things that swayed the court's opinion there was the fact that the agreement to purchase this half share had been registered on title. So whilst Mr. Masters hadn't actually obtained the title to the land, nevertheless he had prudently registered his interest. So anyone that subsequently was looking at purchasing that land would see, hang on a minute, there's something going on here. There is some agreement that relates to the land, and not abandoned in that circumstance. The Pearl Mill and Ivy Tannery case was one of abandonment, and in that case we had sale and purchase of 50 dozen skins, delivery as required. In that case, in the first year or so of the contract, around 20 dozen skins were supplied and purchased. Then the seller heard nothing further for an entire year. They wrote to the purchaser saying, look, do you want us to supply these skins? The purchaser said, actually, no, we've bought them elsewhere. Then another couple of years went by. So the total lapse there was around 3 years. Then the purchaser suddenly says, oh, you know, that 1913 contract, well, it's 1917 now, almost, and we want to have the delivery of the last 30 dozen skins. The seller said, hang on a minute, there's been a delay there of around 3 years. Haven't you abandoned the contract? The court said, yes, the contract had been abandoned in that circumstance. So that is the last way that you might find yourself discharged from a contract. And that is discharge by agreement. Now we need to look at discharge by frustration. Well, we've once again passed our magical mark, so I'll leave this video here and go across to video 4. And until I see you then, bye for now, guys.